Good morning, everybody. Welcome to this live BLM webinar, where we're looking at the issues raised by the cut in the discount rate that was announced by Liz Truss. We're very grateful to have had more than 100 plus registered delegates to this event, and a number of people we know very well. So it's a very well-informed audience that are with us today. So we're looking forward to this. The plan is that we're going to spend about 3/4 of an hour on this discussion. We'll leave a few minutes for questions at the end, and we encourage you to type in those questions on the box on the screen, the relevant section. With me today, we have Alistair Kinley, who's our Director of Policy and Government Affairs, and also Anthony French, who's one of the partners in our catastrophic injury team. And Anthony will be providing some real-life case handling experience of managing the issues that arise from the cut in the discount rate. When we sent out our invitation, we posed a number of questions that we'd be dealing with, and the first one I'm going to invite Alistair to respond to. Alistair, the discount rate, it's probably helpful just to go back to basics to set the scene. So could you just explain what is the discount rate and why has it been cut?
Yeah, certainly. Thanks, Terry. Good morning, everyone. Really, the discount rate, first and foremost, is just a mathematical adjustment. It's really the way by which future income streams in injury cases, that's future loss of earnings and future care in particular, are converted into a one-off lump sum that's paid at the time of resolution, trial or settlement of the case. And the allowance made is on a, as I'm sure everybody knows, a multiplicand basis, with the discount rate being effectively the annual percentage allowance that's made for investment of those damages in the future for the period for which they're allocated. And given essentially this is a rolling up of an income stream, the bigger the allowance for investment income, then the lower the lump sum to begin with. And indeed the reverse applies, i.e. the lower the allowance for investment, i.e. the lower the discount rate, the bigger the lump sum at the outset. And that's precisely what's happened in March this year, when the discount rate was cut from 2.5% to minus 0.75%. And I just want to go into the legal background of that cut for a moment, really to set the scene. The power to set a discount rate lies with the Lord Chancellor, and has done since the Damages Act 1996, and the 1998 case of Wells and Wells in the House of Lords gave a very clear indicator that at that time, according to the judiciary, the best proxy for the investment that should be expected of a claimant with a large lump sum is index-linked government stock. And at the time, that was a reasonable assumption, and that guided the Lord Chancellor's decision after that case, in fact in 2001, to look at index-linked government stock and set a rate based on the yield available in those investments of 2.5%, which applied for, well, nearly nearly 16 years. But obviously the investment world and the financial world is an awful lot different from when it was back in 2001 compared to 2007, but the rate didn't change over that period. However, the investment returns on index-linked government stock deteriorated significantly due to the financial, due to the financial crash, due to regulatory challenges, due to quantitative easing, and a range of factors in the capital markets, such that their use as a benchmark for personal injury awards, came into question. However, the Lord Chancellor has been under pressure to look at this for quite some time, given the divergence on the one hand, the statutory discount rate, and on the other, the returns available in the index-linked market. And on that basis, in March this year, having announced it in February, the then Lord Chancellor Liz Truss said, and you'll see on the slide, that the only legally acceptable rate that she could set was to follow the gilt yield and go to minus 0.75%. And that was a step change which came in mid-March and significantly increased the awards that were made, which is something that Anthony will go into later in this session. But I think there are some clues really as to how comfortable or not the government was with setting that really, really low rate. The language used, this is the only legally acceptable rate I can set, that does suggest a significant degree of reluctance on the Lord Chancellor to do that. And also I think there's further evidence that she was reluctant to do it because only 10 days after she'd set the rate, she started a consultation about what a new process for setting a new rate would look like, and that consultation closed in May.
There was, when that announcement came out, I think there was a range of responses: surprise, shock, and certainly there's been an awful lot of discussion both at the time and since. You mentioned, Alistair, that it seems slightly out of kilter to announce a rate change and a consultation. And so certainly when Liz Truss announced this rate change, and very significant rate change, there was a lot of concern and comment and discussion, and it seems very odd that you announce a significant change in rates and also a consultation. So there's a sense of disquiet sitting behind the announcement there, and I wonder, Alistair, do you consider there's any potential for change?
Yeah, I think that there is, Terry, and certainly you're right to suggest that the consultation following very closely after the rate change itself is an indication of that. And I think also that the fact that there was a short consultation period, only 6 weeks as compared to the more usual 10 to 12 weeks, suggested that the government was in a mood to move fairly quickly here. But over that 6-week period between March and May, we had the announcement of the election, and of course the election result only a few weeks ago has maybe slowed things down a little bit. But just thinking back to the consultation paper itself, buried in there was a commitment by the government to announce the results of the consultation on the 3rd of August over the summer recess. That's unusual. It's normally a quiet period, and that could slip. But I think it's an indication that, again, as I said, the government intended to move quickly, certainly when it started the consultation. And more recently, in the Queen's speech, I think there is a further clue that something may well be done with regard to the discount rate. And that was in something called the Civil Liability Bill, which at the moment, and as announced in the Queen's speech, is intended to deal only with whiplash. But the background material to the bill, which I've put in the slide there, the double arrows, reads as follows: to ensure there's a fair, transparent and proportionate system of compensation for damages to be paid to genuinely injured personal injury claimants. Now that is very wide language, and it's language that's really got very little to do with whiplash, and I think it hints at the discount rate. I'm talking of fairness and transparency. But not only that, excuse me, that language is really very close to language that was used in the introduction itself to the March to May consultation, and I think that's another clue to the government wanting to do something here. So more recently, after the election, back end of June, the new Economic Secretary to the Treasury, Stephen Barclay, gave a speech where I think he gave some more indication that the government wants to do something and is likely to do something, perhaps in the Civil Liability Bill, as I said. He talked of the discount rate in a wide speech about matters of interest to insurers as a mechanism that was outdated, negative returns, and it's lost its connection with how people invest. So I think there you get a clear steer from the Minister that this needs to be updated. we've got to look at something that generates perhaps a positive return for claimants, because nobody, one would have thought, would invest in an asset that yields a negative return. It doesn't really make much sense. And the fact that it's lost its connection with the real world, in his language, to me seems to suggest that if the government's looking for a new benchmark to replace the index-linked gilt yield, it's going to be looking at something that reflects some analysis of what people actually do or are advised to do with the compensation that they get for these very serious injury cases.
It is curious timing. 3rd of August is during the parliamentary recess, and that is certainly usually a very, very quiet time for government activity. But you know, it does seem there is some momentum behind considering the change and how to effect the change. And I think, going back to our own poll, there is circulating a claimant poll. I mean, I think clearly here we're addressing a largely defendant audience, but there is a claimant poll that was apparently commissioned by Bill Braithwaite QC, very well-known claimant, Silk. The response to that was that only 10% of claimants were expecting the present rate of -0.75% to remain the change, which is not so very far from the 7% that we had in our own poll. And I think it was about 2/3 of the people who responded to that poll were expecting it to move to between 1 and 1.5%. So again, maybe a little bit more pessimistic if you're a claimant, or optimistic if you're being a defendant, than our brief and unscientific poll that we've popped up here. So thank you. We've touched on this in part, but I'm not pressing the button hard enough. But can we move to the next slide, possibly? Thank you. Timing of any change. Alistair, we've discussed the consultation, discussed some of the difficulties with the government. We haven't discussed impact Brexit on that.
Yeah. I think Brexit is very much a sort of hard time limit. March 2019 is when the end of the 2-year Article 50 period comes to pass. I think there'll be a logjam of Brexit legislation in the run-up to the March 2019 deadline. And it seems to me if there's going to be legislation on this area, and we mentioned the Civil Liability Bill a moment ago, that's going to have to be done and dusted and well out of the way before we get to March 2019. And if that's correct, then there is a certain amount of core time and then irreducible time that a bill needs to take to go through Parliament. And if something is going to be commence its parliamentary process, perhaps this autumn, then it may well pass all of its stages by sometime in the spring, late spring, and one could perhaps see it biting and the change coming into effect maybe in October 2018. I think settle on that for 2 reasons. One, because it comes in under the sort of Brexit logjam I talked about, but also in the whiplash space, which is where the Civil Liability Bill at the moment is primarily headed. The government had, before the election, talked about bringing in reform to whiplash and small claims by October 2018. And if it's going to stick to that timetable and include provisions around the discount rate, then that would seem to make something of a package for that bill that would all come in around about the same time, sometime late 2018. But I would stress these are very much only informed guesses, really, and this, as I said a few minutes ago, it could get a very rocky passage in Parliament, and there might be certain compromises that have to be struck as the bill is debated.
And I think that time limit is relevant because there is, undoubtedly a strong claimant lobby, which will be very unvociferous about the change and the detail of the change, with perhaps amendments coming in, and anything that might delay the passage of a possible change to the statute might mean that it's going to get quite difficult if it gets caught up in the sort of time amongst the Brexit legislation, because it's a very heavy parliamentary timetable to encompass all of that, which is going to really start accelerating towards the end of 2018.
Yeah, I think that's right, Terry. And I think something else to be a little bit concerned about in connection with the prospect of legislative change is that we're in a completely different world now. For sort of 16 years, the interests of defendants and the payers of cases was to uphold the status quo at 2.5%, and that requires a certain type of tactic and lobbying behaviour, whereas now the interests, arguably, of defendants and those paying claims is to change the status quo, change the minus 0.75 status quo, and the kind of behaviours you need to engage in to achieve that lobbying outcome seem to me to be completely different to those associated with preserving a status quo. So the rate's changed, and the way you engage with the rate has also changed significantly, and the parliamentary arithmetic's changed a lot. So there's not any certainty in this, far from it, and it will be it'll be controversial, and as you say very rightly, there are bound to be significant amendments, and as I said before, perhaps a risk of compromise. Just one point on the slide there that we haven't covered so far is really the hint there at a shadow panel. This was mentioned in the recent consultation, and there's an idea that rather than having the Lord Chancellor prescribe a rate, there could be a panel of perhaps judges, perhaps lawyers, perhaps economic and actuarial experts who would carry out analysis of what goes on in terms of investment behaviour and investment responses by claimants, and then either take the decision to set a rate or advise the Lord Chancellor or another minister what that rate should be. Now, as a model, that no problem at all with that, and it's a valid model and one that could work. However, the reason for mentioning it here is simply that if there was a panel and that only started its work after the bill had gone through, then the panel might only start, say, in May, June 2018, and it might not have enough time to do the work before the end of the year. So one thing that was hinted at, and perhaps not stressed enough in the consultation, was that there might be a shadow panel doing this work. So it would do the work at the same time as the bill was passing, and then that work could be validated when the bill was passed, and a new discount rate could commence relatively quickly if that route were taken. And I think that is a possibility if the government's looking to achieve a timely change before the end of 2018. But a word of warning and a sort of reality check, I'm fairly confident that if there is a shadow panel, it'll be very, very difficult to get any information about what it's doing, or indeed whether it's happening, because if there is widespread knowledge that there is work going on, that will simply stop settlements, because those who have interest in anticipating the new outcome may well want not to settle cases, and kind of vice versa. So it's a distinct possibility, but the visibility of a shadow panel, or indeed any activity, I think is something that is really going to be extremely low, if visible at all. But it might be one way that this process is, to a certain extent, depoliticized by some other body doing the investigations and then either making the decision, or I think, as is more likely, advising a minister or a number of ministers of the decision that should be made.
Thank you, Alistair. I think there's some sort of good practical tips there that and which really brings us on to Anthony. I'd just draw you in now, Anthony. Can we have a chat about some of the implications? I mean, you're also a practicing lawyer. You've got cases on your desk now, and over the last 3 months. Could you just sort of think about some of the issues that you've seen?
Yes, certainly. Good morning, everybody. Well, I think that if we just take these points in order through the slide, and what I'll try and do is reflect on some of the activity that I've seen on a day-to-day basis, but also the activity that the firm as a whole has seen. And this is a subject which is obviously close to everybody's heart, and one that BLM continues to take incredibly seriously, and we're actually coordinating on a national level to draw in intelligence and really understand what the market is doing about this. I don't mean the market in the sense of our customers, but I mean the claimants and the claimants' advisors. What are they doing, and where are the areas that we as defendant practitioners and lawyers should be focusing our efforts? So looking at the starting point here is that I think I'm going to start with damages awarded, because I think that drives everything else. It's obviously undoubtedly the case that we are seeing cases where damages are increasing significantly. On a broad brush basis, you could take a 50-year-old man, for instance, and say that his future losses will increase by roughly a third. Now that's even more stark when you take someone from the younger generation, and if you took a 10-year-old girl, her multiplier has moved from around 40 to 110. So you're automatically seeing any case in which a future losses involved, damages will increase significantly. Now, it used to be the case that you would essentially get a discount for settling a claim early through the accelerated receipt, but that discount doesn't even exist anymore. In fact, cases where there is a fixed term has actually increased, so they recover more now than they would do in 27 years. Now, that is obviously absurd, but that is driving an increase in damages being awarded to claimants. The other point to mention here is that largely is a consequence, obviously, of the discount rate being moved downwards and multipliers increasing. But that doesn't necessarily follow that all cases are settling at minus 0.75%, and certainly that's our experience. I think we can probably safely assume that any case that goes to trial in the next 12 to 18 months, and at least until that is reviewed, a court or judge will undoubtedly apply the law, and that law is apply the discount rate at minus 0.75%. But we've already touched on the claimants having a poll themselves anticipating a move to something in a more positive range. Now, that in itself is creating opportunities to reach agreements with claimants in certain cases. And we have seen, and I've had a case personally where we settled at around 1%. Now, that was involving an infant who lost a limb. But there were lots of issues at play in that particular case, liability being the main driver, and there was no certainty that the claimant was ever going to succeed on primary liability. So that case is actually awaiting approval at the moment in the court, but the settlement was agreed at around 1.5% on the total valuation through a mediation scheme. Now, it'll be interesting to see what the court do there, but I anticipate that the claimant's advisors will make it very clear to the court that there is a significant risk that that claimant will not recover anything, and that the award should be approved. So if we look at these sort of efforts to reduce the claims and what we can do there, largely I think this is going to be driven by the court timetable. We've already seen claims that I've talked about in the next 12 months being constrained by the current discount rate. And I've seen instances where claimants' solicitors, leading law firms for the claimants, are now trying to convince the court that they should be timetabling a 9-year-old traumatic brain injury claimant through to an assessment in the next 12 months. I mean, that's just unheard of. It's ordinary practice for most claimant practitioners to say, well, we need to see how this young child gets on through adolescence, and we can only properly judge matters when she becomes 16. We're seeing claimants themselves taking steps to try and maximize the opportunities that exist in the current landscape. So what can we as practitioners do to try and change that? One of the main drivers here is going to be liability and contributory negligence. Everything will hinge on that, and that can be used as a lever to open up alternative conversations at different discounts rates, particularly as the risk a claimant may not recover in full. We need to focus on the multipliers, but in doing so, there's two strands to that. One, get the multiplier right, but also look at the evidence on life expectation. It's an area which perhaps has gone unexplored. Smoking has an enormous impact on life expectation. We know that. Get specific evidence to deal with it. Look at other unrelated conditions, diabetes, etc. All of these can have a significant reduction in life, and that will save you those final few years when the multipliers increase substantially. You may want to look at focusing on individual multiplicans, removing the impact of the multipliers. So really focus efforts on head of loss containment, I would suggest. Also look at maximising opportunities that have presented themselves through this reduction in life expectation. We'll all have seen that claimants, advisors are now seeing this as an opportunity to attack the methodology of Roberts and Johnson. But there's an argument that the law in that is sound, and if that is the case, the claimant recovers nothing by way of a Roberts and Johnson award, and there may be opportunities through purchasing or making funding available for a claimant in return for some other aspects which the defendant might value as important in the assessment of damages. The forms of award themselves, this is an interesting question, and I've been to a number of talks on this, and claimant financial advisors continue to tell us that their advice to claimants in the most serious cases is that they should continue to take periodical payment orders. They say that that is the only way of guaranteeing a secure, continuous income throughout the claimant's life. Now, that is probably true in the most serious cases, but those cases which were once £1 to £2 million through a moderate walking wounded brain injury, which is now £5 to £6 million, what is the appetite for a claimant to take £25,000 a year as a periodical payment, and what is the appetite of the insurer? Do they really want to do that? Our experience tends to be that insurers tend to prefer not to embrace the periodical payment for all the reasons that have been explored before.
So the larger lump sum remains attractive.
I think it probably does.
Okay, and that brings us nicely on to our sort of next slide, because the value of these claims have moved up very substantially. And just to like to have a look at the reinsurance impact and some of the consequences for buyers. Again, Anthony, I mean, if you'd like to have a quick look at this slide.
I think Alistair and I will share this, but I think the slide is illustrative itself. The excess layer is going to be more regularly breached. That is undoubtedly the case. We'll see shortly that the number of awards in excess of £10 million is now just very common. We're seeing schedules regularly in excess of £20 million. So it follows that where the excess layer kicks in sometimes between £1 to £5 million, it's going to regularly be hit, and we're likely to see reinsurers look at that particular book and think, well, how are we going to offset that? And that's going to, I would have thought, lead to increased premiums.
Yeah.
What's your thoughts, Alistair?
Yeah, I think that all things being equal, that's what we would expect. And the little table on the slide there is really just an illustration of the gearing effect that the discount rate reduction has produced on excess layers and reinsurance. And you can see that there's a differential in the level of impact, and what is quite a modest increase due to the lower discount rate. But in that example, you've got nearly a doubling, or a 100%, 75% increase, nearly a doubling of the spend by the excess provider or the reinsurance provider. And as I said in response to Anthony's question, all things being equal and subject to market conditions, you'd expect they're going to want more funding for that. And I think the proof of that pudding is going to be really on the sort of 1st of January reinsurance renewals.
There's also been a lot of conversation about policy limits. Certainly, I've done presentations for brokers where that has come up. Subsequently, been asked to prepare blogs about it. Yeah, I'm not sure whether Anthony.
I'll take this again. I mean, I think as I've touched on already, and the first paragraph says it all. I mean, the £10 million claim is no longer uncommon. It used to be that a tetraplegic would be anywhere between 8 to 12 million. Well, that's now going to be more likely to be 15 to 25 million. Now, that raises some interesting questions. I mean, for the RTA insurer, of course, it's of no significance other than their excess layer will pick that up. But where the insurers that are writing EL and PL business, they're going to see some changes there. We know that the statutory minimum for EL claims in the UK is £5 million. Now, the question has to be asked, is that significant? is that adequate? And if not, what are the consequences for that? We've got PL cover where there is no statutory requirement, and it's often, particularly in the SME market, down at £1 to £2 million. You now only need a complicated orthopaedic claim, potentially a mild brain injury, and you're going to be talking claims in excess of £2 million for a young claimant.
Should we look at our next? I think these were two of your cases, were they?
Well, these are two cases I've collated internally. I can't claim any personal credit over these, I'm afraid. But these are two cases that have come in across the BLM National Catastrophic Group. And these are some really interesting cases. They're illustrative because one is an EL with a limited indemnity of 10 million, and the other is a PL claim with a limit of 2 million. You can see there that in the first case, we've got a tetraplegic who fell from a tree. Well, that claim is now just shy of £21 million with a limit of indemnity of 10 million. Well, what's going to happen to the claimant who's going to uncompensate for that value? What's going to happen to the insured company? Are they going to be insolvent as a consequence? Can they bear that risk? Is it going to go on their balance sheet? All these things to think about. And then finally, you've got a potentially what was once a relatively low-level claim, now breaching the 2 million policy limit. Immediately, the advice is, well, let's hand over the 2 million limit. And again, what happens to the claimant? He goes unrecovered for the shortfall. And the same risk exists for that company of becoming insolvent.
Yeah, which is just sort of takes us on to our next slide. So some of the issues here that arise for policyholders.
Yeah, these are really driven by obviously the increased cost. But and I've touched on a few of these points already. But what are the individual insurers going to be advised to do here? Are they being advised now, following this change, that their level of cover is no longer sufficient? And should the brokers and insurers be advising their insurers of these potential risks? What are the government going to do about the statutory EL limit? Even if we end up in a world where the claimant lobby and perhaps the majority of our poll think, and they end up somewhere between 1 to 1.5%, there has to be significant questions outstanding whether the current limits are even sufficient in those circumstances. A 25-year-old currently at 1 to 1.5% would end up with a multiple of about 40. Well, old money, as we might put it, that was about 30 to 35. So there's still going to be an enormous increase in value of claim as to what we've been used to in the past 16 odd years. And there's going to be impacts on the statutory limits no matter what change we get. Do you agree, Alison?
Yeah, I think that's right. It's impossible to predict what the government might do with the EL statutory minimum. I mean, arguably, they might take the view that it would be imposing an extra burden on business at quite a difficult time because they'll have to buy more protection at higher cost, as we've discussed. But equally, perhaps they might think that it's a prudent approach that businesses do secure adequate protection for the risks that they face. It's not a debate that's been explicitly commenced, but I think it has to be a risk and one that this market needs to engage in terms of providing products that are fit for the risks that its customers face. So, a tough one and slightly off the radar at the moment, but given the levels of awards we've been talking about, it probably has to come back fairly quickly, and we'll see where that one goes.
And a less complicated change, because it would just be a mere change of a statutory instrument, no doubt following consultation and the like. But when we're not talking about legislation and Brexit vortexes here, are we really? So. Thank you. And I think, Anthony, just to pick on your point, what should brokers be doing? I think they've absolutely got to be telling people, have you got enough cover? I mean, raise the question. I know it must be very, very difficult to have a conversation about negative discount rates with policyholders, but I certainly feel that brokers should be having that conversation as whether there is enough cover. Because you can quite see a situation where a substantial claim is put forward, policyholder says, well, no, I've got enough cover, and then have the difficult conversation, well, actually they're £3 million short. Well, I can quite see that it will be the broker who's asked the very next question is, why didn't you tell me? We're into question time now, and we've had Jonathan has raised a technical one, which is going to be for Alistair, but gives me the delight of trying to work out whether a parliamentary acronym is EVIL or EVIL, and the question is whether we can elaborate on the potential for the civil liability bill to be an EVIL matter, insofar as it's possible to successfully pass through Parliament.
Yeah, it's a great question, and slightly procedurally complicated. But what we're talking about here is English votes for English laws, and the numbers in Parliament. Just given that there are about 60 MPs in Scotland and Northern Ireland, if you exclude those for the purposes of a vote on a purely English measure, which is what English votes for English law means, then the Conservatives' minority becomes a majority in respect of English and Welsh constituencies. And if, as may well be the case, the civil liability bill is limited to England and Wales only, and it is for the time being for whiplash, and presumably if the discount rate were to come in, it would be limited as well, then the arithmetic in Parliament is more robust in favour of government activity, but the procedure is not guaranteed. And it doesn't apply to all the stages through which the bill would progress. But certainly I think absolutely right to point out that it is England and Wales only. If those provisions were to apply to any legislation around the discount rate, then you do see slightly more favourable numbers for government activity on this one. Sure.
Thank you. As I say, sort of we're into questions now. I think most of the questions that are coming in probably sort of synthesised into sort of the timing. And I know we've covered it, but as we finish off, let's just have Alistair again, perhaps sort of timing for potential change.
Well, I think, as I said, in the body of the webinar, October 18 for something to bite seems to be realistic. A bill has, a core irreducible period that's got to go through Parliament to go through its necessary stages. That could probably be sort of autumn through to spring, late spring, and then commencement in October. That I think at the moment is, would be my best guess, but it's far from guaranteed.
Yeah. And again, I think the theme of the other questions, Anthony, I think people are finding it helpful to have that broad feedback. How is the market behaving? Where are we on settlement? So I know we've covered it, but just briefly before we finish,
there is a lot of cases that are the cases that are coming up for trial, are listed for trial in the next 12 months. Claimants, in our experience, where they have a liability admitted case, will hold out for a valuation at minus 0.75%. There will have to be something else in the case that will require them to be flexible in their valuation of the claim. That may be liability, it may be life expectation, there may be some other feature that we don't know about. I mean, like a lot of these cases, what's really going on in the claimant's mind and what's driving the settlement decisions, you just have to try and get to the bottom of that and open it up. For cases that are requiring court approval, again, it's going to be minus 0.75% unless there is something spectacular going on in the background that you don't know about, or that there is a risk that the claimant may lose a significant proportion of his damages. Largely speaking, I think that whilst we're in this window of minus 0.75%, there are deals to be done out there. They need some careful management. You'll need to get the right evidence in place to contain heads of loss. You need to get evidence to attack life expectation, to try and reduce the multiplier, and where there are opportunities to argue for any sort of liability discount, then you need to do so, because it's those opportunities that will open up the doors for alternative conversations around the valuation of the claim. That's my experience.
Okay, thank you, Anthony. Thank you, Alistair. No, I think we'll conclude there. We're more or less finished our 3/4 hour slot. Just like to thank Anthony and thank Alistair for their contributions and all the prep that they've put into doing this beforehand. With me in the BLM studio are Chris and Lisa. I'll take the opportunity to thank them. Of course, thank you to all of you for tuning in, listening. Thank you for your questions. We have recorded this and it will be available should you want to listen again or refer it on to colleagues to listen to, as no doubt as part of their CPD training points, whatever. Alistair mentioned that we did prepare a very thorough response. Now, that's the collective we, because I played no contribution whatsoever to it other than to do some reading through with perhaps one or two suggestions, but it was certainly an excellent, detailed and well-argued response, and I'm personally very proud of what BLM did there. And two of the authors are with me in the room. If you would like to see that document, please, as they say, DM me, and we'll make that available. And also, for some further conversation to keep up to date, if you keep an eye on the BLM Red blogs as well. If you're not already a subscriber, again, I recommend those to keep you up to date. It's very, very often Alistair telling you what is just about to happen. So thank you to everybody for listening, and that concludes this BLM webinar. Thank you very much indeed.